Okay, so it is 1. So let us start with the class. Okay, those of you who are new here, right, for the first time, those of you who are here, let me tell you that each day I am taking 2 classes, I mean 2 topics, and I am trying to explain that, okay, that what to study in that particular topic, right. I mean the purpose is to enable you to study by yourself, right. If you look at the books, very heavy books, right, so what part you can study and what part you can skip, okay, so that is the whole purpose, okay, so remember that. Now let us start with the today's class. Now if you look at the topic today, right, so the topic 1 that I am discussing is the topic 1 is the criminal attempt and preparation of the law optional, right, and the second is topic 2, that is your general exception, okay. Now if you look at these 2 topics, right, these are topic number 3 and 4 in normal order, right, in a general order, right, but here this is topic number 1 and 2 that I am discussing, okay, so remember that point. Now the question is that what to study in these subtopics, okay, so let us see. First, in the case of topic 1, you have to understand the difference between preparation and attempt, right. You all must be knowing that a crime passes through multiple layers, right, multiple stages, right, and the most toughest thing to distinguish is that where the preparation ends and where the attempt starts, okay, so that that distinction you will have to study by yourself, right. Then what are the various theories, right, that actually defines that where the attempt starts? You must have seen, right, there are multiple theories, right, last resort theories, right, there are public danger test, right, so there are multiple theories, right, that you have to go into very detail and understand that what are those theories, right, and then you have to do a comparative study of those theories, right. There are multiple theories to define attempt, so you have to do a comparative study of those theories, right. The reason I say that, multiple time a question have been that, explain that how the defining attempt have been a frustrating exercise, right. There was a very interesting phraseology of the question as well, that an attempt to define attempt have been a frustrating exercise, okay, so very interesting phraseology, right. So that particular thing that you have to take into account and understand it, okay, so that how the define the word attempt varies according to different test, right. So if you apply one test, attempt might be something else, and if you apply a different test, attempt might be something else, okay, so you have to go into that and do a comparative study about it, okay. Then you will go to the specific offense, right, section 511 that talks about attempt itself, right, in the IPC, okay, so we will go into detail of that, right, and then you will try to understand that what that particular 511 says, right. So it says that if attempt is not specifically defined, attempt to do something shall be a punishable offense which is already a crime, right. Understand that particular point. And also it says that in the case of attempt, right, the punishment will be actually half of what is normally provided for a particular act, right, unless otherwise provided, right. So if IPC provides something else, that will prevail, not this section will prevail, okay. So we'll go into detail what are the essential elements of the attempt in those that you will go into detail. Then you will understand that is there any crime in our IPC that specifically provides that attempt to do this is a crime, attempt to murder is specifically a crime, okay, attempt to theft again is especially a crime, right. So you have to go into those crimes specifically who have been provided as attempt to do that particular crime as a separate section, okay. So you will have to go into that, given in the notes as well, you will see that. Then you will come to okay, so in the case of preparation attempt, only these 3 things has to be understood, right. Now when I'm talking about different theories, right, then you have to read the case laws also in which that theory have been applied, okay. So there write that down also, right, case laws along with case laws, okay, right. So only these 3 aspects has to be studied in the case of preparation and criminal attempt, that's it. Then you will go to the general exception. Now if you know general exceptions, there are multiple general exceptions, right, so we'll go into detail, right, and philosophically we will try to understand that why this general exception have been given, right. See, most of the general exceptions are those whereby a person do not have mens rea to do that particular act, right. So mainly those are accepted in general exceptions, right, they are written in general exceptions, okay. So what is the usefulness, right, I have also given in the notes that why these general exception have been provided, right. So public policy is also one of the ground, right, protection of society is also one of the ground, okay. So there are multiple grounds, I will talk that in notes as well, right. And then you will go into detail of general exceptions one by one, right, and also you will try to understand that what is the difference between general exception provided here and general exception or exceptions sometimes provided in a specific crime, right, like in the case of 300 and 299 there are exceptions. If this is covered, it will not become murder, it will become culpable homicide, right? So what is the difference between that exception and exception that is provided generally, right? So you have to understand the correlation between them, right? Okay, general exception which waives all the crime, right? And there have been exception specific to that particular act. Okay, so what will happen, that suppose in a particular crime the normal exception that is appended to that particular crime is covered and general exception do not get covered. So what will happen in that case, or vice versa, what will happen in that case? Okay, so that particular thing has to be understood nicely. Okay, that particular thing has to be understood nicely. Okay, so that is why I have told you, I have written here, go into detail between difference between, right, difference between general exception and exceptions provided in specific crimes. Okay, then individual defenses, right? Now there have been a direct question, right? They give a particular statement of a general defense, general exception, right? And they write, they ask you, they discuss, simply discuss, right? So you go about each and every general defenses, right? And for each of them at least remember one cases, right? At least one or two cases will suffice, right? So no, not go into too much detail about each one of them, right? But in the case of private defense, you will have to go into detail, right? Because most of the times, in fact 60% of the time, if there is a question from general exception, it is from private defense. Okay, right? So you have to go into detail into private defense, right? And specifically in the case of limit, right, that where private defense starts and where does it ends. Okay, so that limit has to be understood very nicely, right? That is actually more important thing. I will see, I will show you in the question as well, right? There are multiple questions which actually only talks about that what is the limit of that private defense, right? Now private defense you must be knowing in the case of property and in the case of your body, right? So you have private defense in both the cases, right? And both of them, the whole section have been defined, 96 onwards have been defined in such a way that you have a private defense up to death and not causing death, right? So up to causing death and up to not causing death. Okay, so there are two type of general defenses in the case of property and in the case of your body, right? In certain circumstances you can cause any other harm other than death, and in certain cases you can cause up to death, right? So you have to go into the nitty-gritty that in the case of property up to what you can cause death, and in the case of body up to what you can cause death, and up to what you can cause harm other than death. Okay, so that has to be in very detail you have to study that. Okay, because there are a lot of questions with that regard. Now let us come some of the case laws or notes, not exactly case laws, notes just for these are only meant for basic things, right? So it is not a very detailed notes, okay, but it will help you at least understand what to study. Now preparation and criminal attempt, right? So you must be knowing it passes through multiple phases, right? Form intention, then he makes preparation, then he commits attempt, and finally he actually do the actual commission of attempt, right? So you have thinking about that particular crime, preparing, going to do that particular crime, that is attempt, and actually committing that crime, commission. Now mostly our syllabus is confined to preparation and attempt, right? So here the meaning of attempt, right? Now one thing that is very important, multiple times this question itself have been asked. Attempt is a mixed question of law and fact, full stop, comment. Simple question. Okay. Now the question is that, how to answer that question, then you will go about different theories, right? And that different theories are basically three. There are multiple theories, but they are the three major theories that I have given in a very short format. Proximity test, right? So it should be proximate to the ultimate event. Okay, what amount of proximity should be there? So that should be natural consequences, right? If you are proximate enough, that will be defined that if that act is left alone, it will ultimately lead to that particular crime, right? So it means that is the proximate. It doesn't mean it should be the last act. No, not at all. It need not to be the last act before the actual crime. It should be last act which left unaltered will lead to that particular act. Understand that particular point? Okay, so that is very important concept. Then we have time for repentance, right? So if you can control yourself between a particular act and actual commission of crime, right? Like you were driving a lorry, there is a very famous case, and you are about to enter into a particular state where that lorry had a certain type of crop which was banned in that particular state, right? Now you were 5 kilometers beyond the border of that particular state, but still you had a time to come back, right? So if you came back even 1 inch before crossing that border state, it means that will be not counted at attempt, not at all. That it is only when you start entering into border, then only it will be an attempt. right? So if you have a time for repentance, you can come back, then it will be not counted as a attempt, right? See, an act will amount mere preparation if the person on his own accord gives it up before the criminal act is carried it out, right? So very famous case actually. The social danger test, right? So you have reached to a particular level that even if the act do not get committed, that act of preparation itself is a danger to society, right? Itself is a danger to society, right? So if you have collected a bomb and put it somewhere, right, and you did not you in between you left that, okay, no planning of now bomb, right, bomb explosion, but still that bomb, the mere collection of bomb is danger to society, right? So that will amount to attempt, not only preparation, right? So that particular thing has to be kept into mind, right, that what are the different way of defining an attempt, okay? And you have to go in very detail. I am talking here very shortly, right, just to give you a sense that what need to be studied. Then you will go to the general exception, right? Now in the case of general exception, there are these 7 you must be knowing, right? So as I have already told you, they gave a particular line and say full stop, comment, right? So read each of the general exception, just normal maximum 10 marker question or 15 marker question comes. Never you will ask, you will have a question which is of 20 marker specific to one thing, right? You discuss accident as a general exception, right? So there is never a question of 10 marker, right? But in 20 marker, but there is a question on 10 marker on that, okay? So just remember each and every sections and little bit about that particular section, so that you can write one paragraph, that is 5 to 7 lines, and then one case law with regard to that, right? Just make a very sweet note. This is general exception, this is the paragraph that I will write, and this is the case law that I will write. Just that, okay? But when you go to this private defense, it has to be studied in little bit more detail, as I have already mentioned in the beginning itself, right? Private defense is actually important. Now if you look at the private defense, here I have given you the major reasons or the philosophical aspect, that why private defense, right? There have been a question on why you should have a private defense, okay? So the first is that he cannot wait for the state aid. Practically it is not possible for the state aid to wait for you. I mean, you can call help and you have no time for that, right? So obviously you can be help for yourself, okay? Now this private defense is proactive and preventive, not punitive in nature, right? That is the second aspect of private defense, that is very important. And third, it cannot be used for self gratification. You cannot derive pleasure out of it, right, for the purpose of defending yourself, right? That actually sort of puts a limit on the private defense itself, okay? Then the third, that this defense can be exercised only when the threat is real and immediate. If you have some illusion that, okay, I might be threatened by this guy and I shot that guy, that is not acceptable, okay? So there must be an immediate threat, okay? So these are the 4 very important things, very shortly again, right? There are multiple other public policy and etc. That is also one of the factor behind private defense, right? But these are the 4 characteristics, I must say, you must remember about private defense, right? So that is very important. Then let us go to some previous year paper, right? Now if you look at the previous year paper, very simplistic question, right? I have taken from de facto law website itself, where I have given topic wise paper of the last year, right? So some of the questions I have taken. What do you mean by private defense? What are the general principle which is the basis of the right of private defense, right? So that 4 general principle you can really write that down. Right of private defense can be exercised only against offender, right? Now this question is saying that there is a limit, right? Now what you have to do while answering this question, that you have to specifically go into those sections which talks about limit. You have to pinpoint the keywords, that okay, it's saying as long as the threat continues, right? So this indicates that the right to private defense is coordinated with the threat. If the threat stops, your right of private defense ends, okay? So you have to pinpoint different sections in the right of private defense and then write in the answers that how that right of private defense will function. Remember that particular point, it is very important to understand, okay? Hopefully I am making myself clear. Yes, everyone? No? Achha, yes. So some of you are saying yes, some of you are saying not yes, okay. So that is, you have to go into specific sections. That is very important, right? That is very important. Then under Indian Penal Code, there is no right of private defense in the cases in which they have a time to have recourse to the protection of public authorities, right? So you have to go to the again different sections where the word public authority have been used. Okay, now I have a time to go to public authority, then I do not have a right to exercise the right of private defense, okay? So that particular question. Similarly, in the case of crime attempt, various stages of the crime, how is the stage of attempt punishable under the Indian Penal Code? ठीक है. So you will write different stages of the crime. In fact, that paragraph that I have given you in the beginning, that will be, I think, a very good paragraph in that particular answer. ठीक है. That paragraph is a perfect paragraph, different stages of crime. Okay. And then you will go about how the stage of attempt is punishable, right? So you will talk about different tests, and then you will finally talk about section 511 of the IPC, right? That talks about attempt as a distinct crime. So you will write their ingredients, right? And then you will write some of the example or case law where this thing have been amounted to attempt, or the case law where that particular activity was only it only amounted to preparation, right? Mere preparation, not an attempt, right? There is a famous case that a person was going for smuggling and the police was tracing him. Now he understood that the guy and the police is tracing him, right? So what he did, that he was going for smuggling, but once he realized that the police is tracing, he came back, right? Now the question was whether it was mere preparation or attempt. And there is one more case, state of Bihar, Abhinand Misra, I suppose, right, where he filled the form wrong form, but he did not went to give the exam. Now the question was, that was the attempt of cheating or the cheating has happened, right? So the court held that it was attempt. As soon as you filled the form, it was attempt. Okay, so that is interesting concept there. Now then, attempt does not happen all of a sudden. It passes through some stages, right? So you have to talk about different stages, and then you have to explain the interconnectivity between those stages as well, right? How intention leads to preparation, how preparation leads to attempt, and how attempt lead to commission of a crime, right? Discuss and distinguish between preparation to commit an offence and attempt to commit an offence, right? So you will write multiple theories again. Answer will almost remain same, right? And then you will write cases, one cases on each side. One cases where the act only amounted to preparation, and one cases where act only amounted to attempt. Okay, so two cases, and you will bring out the difference between these. Okay, so that is again very simplistic form. Then this question, very interesting phraseology I told you, right? I've given in the this test series of mains as well this question, right? Very interesting question. And attempt to define attempt has to be a frustrating exercise. Okay, right? So you have to actually write different and this question I am giving to you as well. Okay, that day after tomorrow you will submit me, that you have to write the different theories of attempt, and you have to criticize it, that how given in the one fact, if you will apply different three theories, different result emerges. Okay, so you have to bring out the difference between, conclude with that yes, it is a mixed question of law and fact, and it is sometimes so intermixed that it is impossible to actually bifurcate or sever what is a question of law and what is question of fact. Understand that particular point. Yes, Yaqub Menon case is also important. Yes, very correct. That is the same case where smuggling, he went for smuggling through sea, right? That is the same case. Okay, understand that particular point. Now if you ask me truly, it will hardly take one day to complete you these two topics, right? So if you sit for 6-7 hours, right, so it will be finished, right? It will be very much finished. Okay, now one student have submitted me the copy of the last question that I gave to you, right? So let me check it. I think it was, I don't know who only one have submitted, but that's all right. I mean, even if 10 people will submit, I will take only one. Crime. Now see, I am unable to read it even it. If you write like this, believe me, the examiner will simply give you average marks, and that is why I always told you three things has to be taken care of, right? The first thing is the structure of the answer. Structure is the heading and subheading, right? So I think here very nicely heading and subheading have been provided. Okay, constitutional perspective will be much better subheading here, right? So that is okay. Structure part is good. Second part is content. Content is the quality, that whether you have exactly answered what have been asked or not. And third is basically your presentation. Presentation is the little thing, like handwriting is one of the important part of presentation. Now look at this answer. Structure seems to be fine, but presentation is very bad. I am in fact unable to read the question itself. Discuss the various, what is this? Sanctions punitive and in no way remissible by any private person, but is remissible by the crown alone if remissible at all. Now a crime is said to be commission, omission contrary to the law. Okay, so you have defined crime very nicely. Now punitive action, social order. Okay, so you have given multiple subheading as well. What are the reasons? So that is very correct. Remissibility of a crime, very good heading actually. Okay, so the structure is very nice actually, right? The main problem seems to be in presentation, right? The structure is really very nice. And the crime is committed against society at large. Okay, very good. the controlling power of state, ठीक है. However, see, with common law system of jurisprudence, the Indian constitutional also bestows upon the president. Okay, ठीक है. So here you could have written in the constitutional, the separate subheading could have been provided here. Okay, because you have written something, now you are changing the perspective. Okay, so once you change the perspective in answer, if you take a different perspective, you give it a subheading, right, so that the examiner will know that from here something else is written. नहीं तो एग्जामिनर को ढूंढना पड़ेगा उसमें कि कहाँ पे क्या लिखा है, राइट. सो दैट शुड नॉट बी देयर. ओके, अच्छा, शिवांगी, आई थिंक शिवांगी हैव एक्चुअली सबमिटेड इट. गुड. प्रेसिडेंट, ओके, गुड. you know the same thing you can write president or the governor, right, which is considered the head of the state or the who is representing a state, right. So you can write in a general sense because this question not is specifically related to that. Okay, so write more generically. Efficient functioning society. Okay, ठीक है. Conclusion seems to be okay, right. So this answer seems to be okay. The only thing that you need to improve, Shivangi, here is the presentation part. Okay, understood. Otherwise the answer seems to be okay. Content is also fine, structuring is also okay, and content some problem that I showed you, right. But this presentation part is bad, right. So I have given in the very first lecture I have explained you there have a difference between presentation, structure and content. Each three has to be taken into account, right. Then there will be a perfect answer. Okay, chaliye. So that will end our today's discussion. Now if you have any question, right, one by one you can go ahead and ask me. Yes, Akansha is asking, sir, in tempt we have to cite section 3. Yes, you have. That is the only crime actually where only the attempt is punishable, commission is not punishable, right. So that is, I mean, that has to be cited. Very importantly, that has to be cited, right. Okay, done. Chaliye. So this PDF file which have all the questions, right, I mean this notes I will send you. Okay. Now tomorrow I will be again topic, I mean day after tomorrow on Friday I will be taking 2 topics again of the next in order in the case of law of crime, right, and I will try to explain that, right. I think we have this inchoate offences, this conspiracy and etc., and we have crime against body, right. So that is the 2 topic I suppose, right. I mean we will see that, that's not an issue. Okay, done. Yes, that is very correct, Akansha, that is very correct. Chaliye, so let us wind it up for today. I hopefully I mean you will be able to now do it by yourself. Okay, done everyone. Chaliye, thank you very much. Let us meet on Friday. Okay, chaliye, thank you. Now those who have come late, please keep in mind that on Monday, Wednesday and Friday I take 2 topics and try to explain you 15-20 minutes. I will not take more time, right. And if you have any question you can come and ask me. Okay, chaliye, then that will be all. Okay, thank you very much.